Go on page 6, C, 377239, State of Nevada versus Deon Michaels. May the record reflect that Ms. Michaels is present in custody. Mr. Patrick is here on her behalf. Mr. Giordani and Ms. Griffith are here on behalf of the state. Mr. Date time set for sentencing. Are both parties prepared to go forward?
Yes, Your Honor. Yes, Your Honor.
All right, state this is a stipulated sentence. Anything you want to add?
I do. Just a couple of things, Judge. First, we have 3 victim speakers. I asked if they permitted me speak last.
Okay.
We obviously went to a settlement conference. We stipulated this sentence. I think that the life tale reflects the gravity and the haunting nature of the facts. As you know, the defendant...
Hold on. This sentencing hearing is already taking a dramatic turn. Prosecutors aren't just describing a homicide. They're emphasizing the alleged post-crime actions to underline the severity of the case. In sentencing, details like these can heavily influence how a court views the gravity of an offense. And remember, everyone in this courtroom believes they're here to finalize a deal, at least for now.
Not only murdered her ex, but then desecrated his body by decapitating him and putting chemicals on his body, causing it to burn. The defendant admitted to the fatal blow. She never admitted to the decapitation portion, but the evidence was overwhelming that it was obviously her who did it. Another haunting fact, and something that should be concerning, which supports the life tale, is that the defendant had a corollary child abuse case that pre-existed this. We reviewed, Ms. Griffith and I reviewed the minutes in that case, and it appears that 2 days after she...
Notice how the prosecution keeps returning to the phrase, gravity of the crime. That's not accidental. A stipulated sentence means both sides have already agreed on the outcome. So this portion is often about creating a clear record explaining why that sentence is justified. But here's a question. If both sides already agreed, could anything still derail today's hearing?
Murdered and decapitated her ex. She appeared in court in front of another judge in this courthouse and made representations that she was staying out of trouble and obviously had that on her conscience at the time, walked right back out of the courthouse, and then ultimately was developed as our suspect and arrested. We take this case very seriously, obviously the family does as well. We believe the sentence reflects the gravity of the crime, so we will submit it. We do have some updates on CTS, which was wrong in the PSI.
Correct. I calculated the credit at 455 days as of today.
Okay, that sounds correct.
Because I calculated it in regards to she was on probation when this offense occurred. She then got that sentence imposed. She was released on that sentence, so she started accumulating the credit on that day, and I have it at 455 days as of today.
Yes, and we also have restitution requests. We've now received documentation.
This may sound procedural, but it's actually important. The judge refuses to order restitution without proper documentation. That's a reminder that even in emotionally charged cases, courts still have to follow strict legal requirements. Every dollar awarded must be supported by evidence, no matter how serious the underlying crime.
Actually, I not received documentation.
Right, we just received it this morning. We showed it to Mr. Patrick. It's supposed to be $5,000 to VOC.
I have that.
$1,923 to James Willett.
Hold on just one minute. $1,923?
Yes.
To whom?
James Willett.
Okay.
And $2,500 to Yoko Willett.
How do you spell the first name?
Y-O-K-O.
Okay. Mr. Patrick, have you seen this?
I have, Your Honor.
Okay, what's your position in regards to the restitution?
They had the documentation, we're okay with it.
Okay, state, I'm gonna need you to file that documentation. Because pursuant to the new case law, I can't order restitution without documentation.
Yes, ma'am.
All right. Ms. Michaels, what, if anything, would you like to say before I pronounce sentence against you?
There's so much I want to say. Jonathan was very special, very unique, and I know no matter what I say at this moment, I know right now no one in the family is going to believe me. I know right now no one in the family feels that I am innocent at any point, and I understand that, but I can actually prove my innocence. I actually can, and I'm not going to stop fighting to prove my innocence. I have more than enough, and Jonathan deserves to have the actual person who's guilty behind bars. I was helping Jonathan. I have that I can show that I was trying to help him.
And here comes the moment that changes the entire atmosphere of the courtroom. The defendant has already entered a guilty plea, yet she's now openly asserting her innocence and claiming evidence was altered. That's a huge legal red flag during a sentencing hearing. Judges immediately have to determine whether the plea was truly voluntary and whether the defendant still wishes to stand by it.
This, I know, is hurting the family, and I can see it in your faces, and I know your hearts are angry, and they should be, and I'm angry for you. And this is not fair to you. This has been dragging out for almost 2 years. It's not fair to you. And it's not fair to his children. Any of them. And it's not right. It really isn't. It's not. I've seen so much that it's just terrible. The way that they manipulated and altered and deleted things is wrong. They should not be able to do it, and they have. And for you to be able to look me in the eye knowing that the things are altered and...
You pled guilty, ma'am.
Ms. Michaels, you are not to address the state. You are to address me.
addressing
You
the
are.
state. I
You're addressing Mr.
apologize.
Giordani. You are going to address me. What do
My
you want me to
apologies.
say? What do you want to say to me?
My apologies. I wasn't trying to address the state directly. It's just... I was told.
Did you catch that? The prosecutor just did something many viewers won't expect. He offered to let the defendant withdraw her plea and take the case to trial. That's a remarkable development. Instead of pushing for the agreed sentence, the state is signaling it wants a clean, legally sound record rather than risk years of appeals over statements being made in court today.
I just told one thing after another, and I truly believed that we were going to do the right thing, and it just didn't happen. I am so sorry for all of this, but...
This is the twist nobody anticipated when the hearing began. A proceeding that started as a routine sentencing has suddenly transformed back into an active murder case headed toward trial. The plea is gone, new counsel will be appointed, and the possibility of a jury hearing all the evidence is back on the table. If you were sitting in that courtroom, would you have expected the entire case to pivot in just a few minutes?
I'm so sorry, but I didn't do this, and I didn't know this would end up like this. I really didn't, and I will forever apologize to the family, but I don't know how to fix any of this anymore. I don't. I keep listening to what everyone tells me is the best thing to do. Just do this and it'll work out this way, and follow this advice and we'll do this. And I keep listening to the people because they keep saying this is the best advice. It doesn't turn out the way they tell me it will. And it just gets worse and worse. And I don't know what to do anymore.
Judge, I'm not comfortable with this record. I'm willing to let her out of her plea if the court is inclined.
I don't know how to fix this.
All right.
It's just, this wouldn't be appropriate.
I completely understand.
Let's go to trial.
Mr. Giordani. All right. Ms. Michael, Judge Mr. Giordani says that he's willing to let you out of your plea and he's willing to try this case. And you understand that he's willing to try this case on an open murder. So a jury can convict you of a first-degree murder. You understand that? Or do you want to talk to Mr. Patrick about it?
I don't want to talk to Mr. Patrick. He didn't listen to anything I said.
Miss Michaels, I need you to understand what I'm saying to you and answer my question.
Yes.
Do you want to withdraw your plea and go to trial?
Yes, please.
All right. This plea is going to be withdrawn. Ms. Patrick, I need you to have some discussions with your client
Your
about...
Honor, I've moved to withdraw at this time. This case needs to go back to the appointed counsel.
Ms.
I will-
Michaels, hold on just one second. Ms. Michaels, you need to conduct yourself like this is a courtroom. If you cannot do that, then they're going to remove you because I still have business to conduct.
Yes,
Do you understand? Mr. Patrick?
Judge, respectfully, I move to withdraw and have this case sent back to Office of Appointed Counsel. I am not in a position to accept appointment on this case should it go to trial at this time.
All right. All right, I'm going to have to reach out to the Office of Appointed Counsel and get her a lawyer that's going to be appointed with the understanding this case is 2 years old. This case is not going to sit stagnant and wait around for a trial. So I'm going to reach out to Ms. Bush myself and have a discussion with her in regards to the appointment of counsel because this is not going to be, this case has been delayed extensively and this case is not going to further be delayed so that there is no justice for everybody.
Yes, Your Honor.
And Your Honor, if I may, that's one of the other reasons is because with Barry Edwards, it would be late next year before I would even consider putting this on as a trial.
Well, I'll reach out to Ms. Bush,
Understood.
July 31st, at 9 a.m.
And Your Honor, do you grant my motion to withdraw, please?
Yes, I'm going to grant your motion to withdraw.
Thank you.
Go to my corner right there. Come on, my corner. What were you guys expecting?